first of all, I had to figure out what would be the theory of the lawsuit, right? I mean, okay, so it says that, but on what basis would I sue, and who would I sue? And of course, oh, sorry, this is the next slide I put here, which talks actually about the shelters themselves. And as you can see specifically the shelters, even the shelters in New York were gender neutral. That doesn't mean that they always mix the shelters, but at least the law, I don't know anything about the situation out there, but at least the law was neutral. So that, because what was happening was when I talked to the shelter people in LA, they would all say, well, that's the law. We can't help male victims because the law says we can't. That wasn't true, because in Valley Oasis, they were doing that since the 1980s or in the early 90s. But that was what they would use as their excuse. We can't. And only some of them would even send male victims to Lancaster. Like I said, when I called around, many of them wouldn't even tell me about Lancaster. They would just say, we don't help men at all. So what I started to do, oh, this is Patricia Overberg, by the way. She passed away about, 3 years ago, something like that. And she was amazing, and in fact, she is the one who told me to file a lawsuit. And a number of the other directors are angry at her for that. She was amazing. She defined it, she described herself as a tough old broad, and she was. She really was. She had a really strong New York accent, and she wasn't afraid at all. Erin Pizzey, I'm not going to go all into this, but Erin Pizzey is the English version of Patricia Overberg. Back in 1972, and this is her way back then, she founded the first modern battered women's shelter in the world that's known. And she was very, very active. I forgot what part of England. It's a small city. It wasn't London. But she also talked about male victims. And that got her in a lot of trouble way back then in the 70s, even before Patricia Overberg had made any changes. I mean, really, trouble. She was picketed. She had all kinds of... the people that had been supporting her work were turning on her. And this is her today at a conference. She to this day, still talks about male victims and is trying to help us out. And the media in England has actually done some really good work covering her only the past 5 years. Up until then, no one out there really knew who she was except people like me who were active in this scene. So, anyway, Erin Pizzey. That's at a conference last year. I had to get that picture before she passes away. I don't want to say that, but she is, What I decided after I started figuring out how to file these lawsuits was, first of all, I need to know what laws I can use to sue, and I need some male victims. What seemed most obvious was the Equal Protection Clause. We all know about that, right? And we all know there's one at the federal level. The federal Equal Protection Clause comes from the 14th Amendment. And it says no state shall, and it goes on, and it says, nor deny any person within its jurisdiction the equal protection of the laws. So the 14th Amendment applies to the states. If the federal government discriminates, you use the 5th Amendment. Interestingly, the 5th Amendment does not actually have an equal protection clause, but the courts have interpreted an equal protection clause into the due process clause of the 5th Amendment. So it still does. But this is the federal level. However, what I learned is that it actually, when I researched whether I should file a federal lawsuit or a state one, I decided it was best to file it in the state, and I'm going to explain why in a minute. California's Equal Protection Clause is there's the citation, and it pretty much says the same thing. A person may not be deprived of life, liberty, or property without due process of law or denied equal protection of the laws. The way equal protection works at the federal level, it's different somewhat than California, at least for gender discrimination. At the federal level, what the courts have spelled out, any attorneys here or paralegals? No? Okay. Well, again, feel free to ask me anything. I said that in the beginning before more people walked in. Please feel free to raise your hand and ask anything you'd like. The way they've spelled it out, and this is a really simplistic version of it, it takes like a few weeks of law school, the way they hammer it into our heads with all these different cases. But there are 3 levels of scrutiny. If there's something in the law that you want to challenge and argue that it's discriminatory, especially if it's right on the face, there are different levels of scrutiny that they'll give it, and some types of discrimination get much stronger scrutiny than others. If it's race, for example, it gets strict scrutiny, which means that in order to be legal, that law, that discriminatory law, has to be narrowly tailored to a compelling government interest. In short, another way of putting that is it has to be really necessary. There has to be no other way that's viable. It has to be narrowly tailored to some interest that the government has that's compelling. Can anyone think of an example of race discrimination that would perhaps easily pass this test without controversy or without much? Okay, well, one of them is, the one that comes to mind for me is when there's a race riot in a prison and they need to separate the races. Okay, that's government making a racial classification. But that has passed strict scrutiny. They found, there's a compelling interest in stopping the riot and the violence, and really to separate the races, at least for that time being, is narrowly tailored toward it. So there's an example, but not much. And in fact, the Equal Protection Clause historically was quite dormant for a long time until the Civil Rights Movement came and used it. Not a lot was happening. In fact, if you read it, it sounds common sense, but it really doesn't say a whole lot, denying them the equal protection of the laws. We classify people all the time, right? We say you can't drive until you're 16. Is that denying them equal protection? This is why, as things came up regarding race, gender, and other types of discrimination, this is why they came up with these different levels of scrutiny. It just didn't happen all at once. It took many, many years of different types of lawsuits. Gender was classified under intermediate scrutiny. So not quite as strict scrutiny, but it had to be carefully tailored to an important government interest. Is this making sense? Good. Okay. Thank you. Sometimes I, go off. And then rational basis test is for everything that's not put into one of the other 2 categories. If I sue because I'm wearing a hat and I'm not allowed to get a DMV picture with a hat on while someone with a yarmulke is, or something like that, if it's not fitting into there, it falls under rational basis, and the only question they ask is there any rational basis for this discrimination? Yes, okay, it's all right. And if no, then it's not. And there's lots of different types of cases that have fallen under that, which I'm not going to go all into. But it concerned me a little that gender only fell under an intermediate scrutiny, because with a lawsuit like this, I'm going up against... First of all, I wasn't well funded. I was going to do this lawsuit completely on my own without getting paid. And I might be able to get some help from the organization to do the filing fees and all, but that was it. And I didn't really have I didn't think I'd have media support, and there wasn't a lot of public awareness about this. So I felt that intermediate scrutiny may not be enough. Because if you sue under there, they're just going to say, well, there's more women than men who need the shelters, and therefore this is carefully enough tailored to an important interest. But what I found in my research was that in California, gender discrimination is subject to strict scrutiny, not intermediate. And that was really the one thing that made me say, we're staying in California. And also, I didn't want to go into federal court. I didn't have any experience in federal courts at all. Now I do. I actually have a lawsuit pending, an equal protection challenge against the Selective Service for its draft registration requirements as we're letting women into combat, that kind of thing. But I had none at the time and still don't have a lot. So I picked Sacramento for various reasons. I researched the various decisions, and I chose there even though I'm in LA. But the other difficulty, of course, was finding victims willing to come forward. I could always do something like Doe versus State of California, right, and make it like Roe versus Wade, where you keep their names concealed. But that took a lot of work, and I felt that by putting the name out there as a Doe, it's not personalized enough. I felt like this is something. We did try several angles. In one of the approaches we tried was through what's called civil rights testing. For instance, the Fair Housing Institute will send out people of different races to apply for housing with about similar credentials to see if there's discrimination. And in jobs, too, they've done it. And federal courts, all the way up to the U.S. Supreme Court, have held that those testers have standing to sue. They may not get a lot of money because they weren't really trying to get that job or that house, but they have standing to sue for injunctive relief and any kind of minimum penalties that are there. They're entitled to it. So we tried that approach. We had a guy, in fact, he's here in the audience, Ray Bloomhurst here, call a number of places for help, and they all told him, we don't help men, just like with me, and that was 6 years later. It was the same thing.
Except Valley Oasis.
Except Valley Oasis, the same thing. And we tried that angle. It got into the appellate courts, and they said, no, there's no standing for civil rights testers in California. That was a first-time ruling ever, and that's the way they ruled. So eventually I needed male victims who really needed help. In fact, Mr. Bloomhorst was a victim. He just didn't need service at the time that he called. It had been 10 years prior that he was a victim. So eventually I did find some. And I think I may have a picture. This is the main guy, David Woods. David Woods lived in Sacramento. And he has a daughter and a wife. And he still lived with his wife. And he had been, his wife would just snap and hit him and punch him. All kinds of things similar to my friend. And he's a big guy. He was a bouncer in Houston. And he could have, the way he described it, if I hit her, I could kill her. And he just wanted to get out. And he called, along with his daughter, he called the local shelter called WEAVE, which at that time was called Women Escaping a Violent Environment. And they said they won't help him. And apparently even his daughter called saying, look, my dad needs help. We need to get out of here. And they wouldn't. So he was my main plaintiff for a number of reasons. He lived in Sacramento where I wanted the lawsuit. And also he had a daughter involved. And that brings a much more powerful element to this kind of a lawsuit. And she became a plaintiff as well. I didn't have any same-sex couples, but I could have certainly included them as well. What we did was eventually we sued the state of California and we sued WEAVE. And by the way, WEAVE gets $4 million a year, half of it from public funds, half of it from private. And we sued the county of LA, and we sued the shelter in Grass Valley. Eventually, and it got into the media, eventually it got really intense. I mean, they hired big firms, some of them doing pro bono work. And mind you, this was separate from my employment, so I had to do it all nights and weekends. Sometimes I would come home from work on my lunch break, go into my place and do a phone conference with these attorneys, and then have to rush back to work. It was crazy. It consumed my life for years, even affected relationships sometimes. But eventually, I reached a settlement with WEAVE and LA County. Actually, LA County, we didn't have much grounds to. That's a long and complicated story. But I reached a big settlement with WEAVE. And it was a confidential settlement that I'm really not allowed to disclose the terms of. But I can tell you that afterwards they changed dramatically. And as I was preparing this PowerPoint for this lecture today, I found in 2010, WEAVE was in the news again, and I didn't even know about it. And it was about helping male victims. And it's a very good story that I'll show afterwards. But we reached a settlement with WEAVE. WEAVE even put up a page on their website for male victims. They started taking in men into not just their services, but also they would give them hotel vouchers, and they started group sessions for male victims. They even had one of our experts come and train their staff on male victims. It was amazing what happened with them. But the big one was going up against the state of California. The Attorney General was the one going against me. And at that time, I think it was John Ashcroft, then it changed to, I think, Jerry Brown.
Lockyer?
Oh, Lockyer. Yeah, Lockyer. I'm sorry, not Ashcroft. Lockyer. And then it changed to, I believe, to Brown. And at the lower level, at the lower court level in Sacramento, the judge stated in court that he has seen battered men in his court. So he sympathized. So I thought we were going to win at the lower level. But at the lower level, one day I get the decision, and I was just blown away. He denied our lawsuit. This was about 2 years after it was filed, around 2007, I think. It denied our writ of mandate on the basis that there are more women than men who need the shelters, and that was it. And that's completely contrary to the Equal Protection Clause, which is aimed at protecting the minority. You can't use that, the excuse that this one's the minority so you can exclude them under equal protection analysis. It made no sense the way he wrote it, but I believe what his fear was, and I could tell. His fear was that he felt he would have to invalidate the entire statute, including the $20 million a year that goes to the shelters, in order to side with us. He was wrong, and I explained to him why he was wrong. You remember recently when the California Supreme Court held that denying same-sex marriage was unconstitutional. They didn't invalidate the entire marriage laws. They did what's called judicial reformation. In limited cases, the appellate courts can reform a statute rather than invalidating the whole thing if it's just a minor change that would make it constitutional, like the discriminatory language. As long as you could show in the legislative history that this wasn't contrary to the intent of the legislature. So the day I got that decision, first of all, I was just blown away. I was depressed the whole day and angry. And I told the clerk, this is going to be appealed tomorrow. I'll never forget that. And I did file the appeal the next day, in fact. And from there, I think over a year went on as we challenged it. And I dug into the legislative record. I showed that in the legislative history, when they passed these laws in the 70s, they really didn't even talk about male victims. It wasn't like there was some discussion. They said, oh, male victims, no, we don't want to help them. There was nothing about them. On a few occasions, they used the word victim or used the word persons. And I used those to show, look, their intention was to help victims. They just didn't believe there were any male victims or that there was any significant enough number to help them. And that's what was going on. There was no legislative intent to exclude males. That was part of the argument that I made on appeal. Eventually, there was an oral argument in Sacramento. I went up against the Attorney General, and to make a long story short, I won.